Let's talk about the Maryland expungement process. My name is Max Frizalone, and I'm a Maryland criminal defense attorney. What does expungement mean? According to the statute, expungement means removing all of the information about a case from public access. Whether your case resulted in a guilty, you were acquitted, or the state dismissed your charges, your case may be eligible for expungement, and that eligibility will depend on a number of factors. Let's first talk a little bit about eligibility. Some of the easier eligible cases are cases where the state entered the matter nolle prosequi, declined to prosecute, you were acquitted, or you were found not guilty. Generally speaking, a person will be eligible to expunge these cases immediately, and that can mean the same day you go to court. Where things get a little bit more tricky is if the matter was placed on the stet docket, you were convicted and received a probation before judgment, or perhaps you were just convicted and did not. Let's talk a little bit about eligibility when it comes to these cases. If you look at some of our other videos, you might be curious about what the stet docket is. If a case is placed on the stet docket, it's generally eligible for expungement 3 years after it's placed on the stet docket. Eligibility will be determined based upon the present case you're trying to expunge, but also your present legal status. So if you're facing another case, you probably won't be eligible to expunge a stetted case. Probation before judgment. This is even a little bit more tricky. Generally speaking, a person will be eligible to expunge a case they received a probation before judgment upon after 3 years, or a longer time if they're placed on a probation that's longer than 3 years. So, if you receive a probation before judgment after being found guilty or pleading guilty to a criminal offense, and you receive 1 year of probation, you'll have to wait 3 years. If you receive 5 years of probation, you'll have to wait all 5 years. I hope that makes sense. Then there are some criminal offenses that have longer waiting periods, even if you get a probation before judgment. For example, Maryland recently legalized expunging driving while impaired and driving under the influence charges. They made the waiting period 15 years, far longer than any other probation before judgment disposition. What about guilty findings? Well, if you're watching this video and it's any time later than 2026, there's probably even more offenses eligible for expungement. There are a vast number of misdemeanor and some felony offenses that are eligible for expungement even if you were found guilty. This includes misdemeanors like second-degree assault and a host of other misdemeanors you might not know the name of, and even some felonies like burglary and theft. What currently is not expungible are most crimes of violence, meaning first-degree assault, any form of robbery, any form of carjacking, any form of murder, attempted murder, etc. Now, this might change in the future, but presently the waiting period depends on the type of offense that you were convicted of. Waiting periods as short as 5 and as long as 15 years exist for a variety of different charges. And frankly, I could make an entire video discussing all the different types of charges that are eligible for expungement. But for the purposes of this video, I just want to talk about general ideas of expungement. So, if you're eligible for expungement, how does the process work? When it comes down to the nuts and bolts of expungement, the beginning, the filing of the petition, is quite easy. There's a court form petition that you'll file, and it can be filed in the district court or the circuit court, depending on where your case was. And sometimes your case ends up in both, and there's some extra boxes you need to check. It'll require you to have information like when you were charged, who charged you, and the disposition in court. If you're trying to expunge a case sooner than 3 years after it's completed, you'll also have to execute a waiver, giving up civil liability against whoever arrested you or perhaps whoever charged you, because otherwise those records would not exist for that party to defend themselves if you filed a civil suit. Once you file a petition, the court will review it for sufficiency. If the court thinks it's sufficient, they send a copy to the state, and the state has an opportunity to object. If the state objects, they'll generally tell you and your attorney why. A hearing would be set on that objection. If their objection is based upon the law and they, let's say, win in that situation, you can always refile the expungement if you're able to cure the basis for the objection. Perhaps you filed to expunge something while you had another charge pending. That second charge was dismissed, you'd now be eligible to expunge the prior charge. In this situation, you're able to refile your expungement as many times as necessary in order to get it done. What you can't do is expect that the judge will expunge something which is ineligible. Maryland's criminal procedure rules are very clear about which criminal offenses are eligible for expungement. While this rule often changes, what there presently is not is an ability to argue for a non-enumerated offense. If you're looking for an expungement, I recommend you consult an attorney, and I wish you the best of luck with cleaning up your record. Goodbye.